everyone. It is my pleasure to introduce Heather Zerke, who will be presenting the ethics portion of our CLE. I was rushing to try to get her bio that was presented, and it's a good thing that I know Heather personally so that I can fill in a lot of the gaps. I met Heather back probably over 15 years ago when I was a Cleveland Municipal Court judge, and she was one of the prosecutors in my room. And Heather really impressed me because she had an ability to look beyond just the isolated facts, but to add context to the situation. And she was very artful in crafting very fair decisions. When she decided to leave the Cleveland Municipal Court, she asked me to write her letter of recommendation to the Cleveland Metropolitan Bar Association, and I was honored to do so. She served there for probably, over 10 years, Heather? How long? 16 years. And then we reconnected because when I was the chair of the bar admissions committee, she was the counsel for the Metropolitan Bar Association. And we did some things, I think, that helped improve the process to make it fairer for individuals as they went through, particularly the appeal process. And also just making sure, we agreed on the commitment that, you go through law school, you work hard, that we tried to see what needed to be done to get the person to yes, if there was an issue with the character and fitness that maybe upon further investigation, the person was, in fact, the applicant was. So she has shown herself to me to be very knowledgeable, very fair-minded. And I think that you will enjoy the session this afternoon. She is definitely an expert in the field of ethics and professionalism. So it is my pleasure to introduce you, Heather Zerke.
Good afternoon. I'm so glad to be with all of you. Thank you, Judge Groves, for such a nice introduction. And so, yes, I left the Cleveland Metropolitan Bar Association about 2 years ago, and I'm glad to share, Judge Groves doesn't know yet, that I just accepted a faculty position with the University of Akron Law School. And so beginning in January, you will be able to find me in Akron. I'm going to be the director of their Center for Professional Responsibility. Thank you. Thanks. Just wanted you to know where you can find me next in a couple of months. So I'm going to be talking this afternoon about a lawyer's duty of candor, our duty as lawyers not to make false statements to courts, and our duty to disclose controlling authority. I'm also going to be talking about our duty to conduct ourselves at all times with dignity. And then, time permitting, I'd like to just go back to that time when we all took our oath, when we were admitted to the Supreme Court of Ohio. We all took an oath to uphold the law. There was a time when we all just wanted to make the world a better place. Just this past week, my son, who is in 9th grade, he came home. He's reading To Kill a Mockingbird in his ELA class, and he had to read 2 chapters, and it was going to be such a slog. And I missed the time when we would read together at bedtime. And I said, why don't you let me read those 2 chapters to you? And thankfully, he took me up on it. So I got to read a couple of chapters, and he got to rest his eyes and just love reading about Atticus Finch and reading about his character. It was really fun for me. So, all right. So before we get to that, before we get to our oath, we're going to talk about the duty of candor, and I'm going to be focusing on Professional Conduct Rule 3.3. 3.3a. Yeah, Bridget gave me very clear instructions about how to use this thing, and I'm still doing it wrong. Okay, so 3.3 sets forth our special duties as lawyers, as officers of the court. We are to avoid conduct that undermines the integrity of the adjudicative process. And I have a number of cases that I'm going to be talking about, and you'll see how Rule 3.3 goes hand in hand with Professional Conduct Rule 8.4d, which is conduct prejudicial to the administration of justice. So where you have a violation of 3.3, you're also going to have a violation of Rule 8.4d. Comment 2 to 3.3 talks about lawyers acting as advocates in an adjudicative proceeding, that we have an obligation to present our clients' cases with persuasive force. And this phrase replaced zealousness from the old Code of Professional Responsibility. So you won't find the word zealous in the rules of professional conduct. We are now called to represent our clients and their causes with persuasive force. So there's a balancing act that we have to do in representing clients. We have duties to our clients and we have duties to the court as officers of the court. There's a balancing act. We're not to be neutral in representing our clients, but we can't make misleading statements to court, certainly. So 3.3a has 3 parts. So lawyers are not to make false statements of fact or law or fail to correct false statements. And then part 2, no failure to disclose legal authority in the controlling jurisdiction. And that's not disclosed by opposing counsel. I'm really going to be focusing on these first 2 bullet points. And then the third one, though, in 3.3a, a lawyer cannot offer evidence that the lawyer knows is false. And so you're probably thinking, this is a gimme rule. I would never do these things. I would never make a misrepresentation to a court. And that is probably true just by virtue of the fact that you are all here and you're taking your medicine and you're doing your ethics training. You're probably not going to run afoul of 3.3, but I do have a couple of cases I'm going to share with you where I think lawyers were shortcutting. And that might be something that has crossed your mind. So let me discourage you from even shortcutting. But before I get to that, I want to share with you some breaking news. Maybe you saw this headline yesterday. I thought this was some jaw-dropping stuff. So a DC-based law firm that's representing a lead plaintiff in a class action for years didn't know that their client was dead. So this law firm, apparently, they regularly file actions against banks and credit unions over unfair or undisclosed junk fees. And they have settled a bunch of these cases for millions of dollars over the past few years. And there was, however, substantive litigation. Well, so in at least one other case, they have learned that the lead plaintiff was dead, and they continued to litigate, that there was substantive litigation that happened after the client died. And in this most recent case, the one that is making headlines, counsel engaged in these activities after the lead plaintiff died 5 years ago. So counsel attended a mediation, they filed appellate documents, they arbitrated a dispute, and in the process, they claimed that the plaintiff could suffer future injury. They represented that their client had reviewed documents that were produced in 2021, and they raised new legal theories on behalf of the client. So certainly these were knowingly false statements. Their client couldn't have signed off on what they were doing, couldn't have reviewed any documents. So case to watch. It'll be interesting to see what happens with these lawyers. So my first example of shortcutting, a place where I think that lawyers might, maybe not innocently, but might run afoul of 3.3. My first case is Cofield versus Virginia State Bar. And in this case, a lawyer was found to have violated 3.3 when she knowingly misrepresented the text of the Health Insurance Portability and Accountability Act, which we all know as HIPAA. This was during a medical malpractice discovery dispute. Law 360 reported about this lawyer that she was representing a plaintiff who needed health records from a hospital during a discovery dispute. And the hospital agreed to turn over these records, but they were going to charge a fee for the client to access their information portal. So the lawyer objected to this fee being charged to her client. And so she filed a brief, and she claimed that the statute prohibited this fee. When the judge reviewed the brief, the judge actually went to the statute and discovered that this language isn't in the statute, but figured out that what the lawyer had done was she went to like an FAQ page for the Department of Health and Human Services, and she quoted this language from the FAQ page. So she ended up getting disciplined A 3-judge panel held a hearing and found that the lawyer violated 3.3. She was also charged with 1.1, which is the rule on competence, but they didn't find that she was not competent. She argued that this was just a mistake in formatting, but the court didn't buy it. So this situation sort of reminds me of the ChatGPT lawyers who you've heard about. These are New York lawyers. They use ChatGPT to write a brief that they filed with the court. They didn't know that ChatGPT could hallucinate case law. And so when they get called out on it and the judge asks them about it, they double down, not understanding that maybe what they filed wasn't correct. They didn't go to the source material and question the output that they got from ChatGPT. So they ended up getting sanctions. They had to issue apologies to the judges that they had quoted. And so I think that both of these, so this case with the Virginia lawyer and this ChatGPT situation, these are examples, I think, of lawyers that are shortcutting. They're not doing their due diligence. They're not questioning the information that they're getting or going back to the source material. And they're getting dinged for it by, they're violating 3.3. The other thing that you're going to notice as I'm talking about these cases this afternoon is that it's judges that are calling out this misconduct. The judges are the ones that are catching these misrepresentations and reporting it to bar associations. And I don't know if that's better or worse than being reported by a member of the bar by another lawyer, but it really hurts your credibility, of course, if the judge has to call you out on your misconduct. That really hurts. So the next case of shortcutting is disciplinary counsel versus Moore. And in this case, the respondent was hired to handle a child custody matter. A grandmother came to her and hired her. She wanted to get emergency custody of her grandchild. She had concerns about her grandchild's safety when she was with her parents. And so certainly the lawyer understood that it was a serious and urgent situation. And so the lawyer drafted an emergency motion for custody and an affidavit. So that was the right thing to do, to take that action right away. However, the lawyer signed her client's name on the affidavit and didn't note that she had signed it with consent or anything like that. And then she notarized it. And of course that, there's the statement that it's sworn and subscribed in my presence. And so that was not true. So the lawyer got a public reprimand in that situation. Okay, now we're going to move on and talk about the lawyer's duty to disclose adverse authority, also part of 3.3. And in this case, we're talking about, so this is the League of Women Voters of Ohio versus the Ohio Redistricting Committee. The League of Women Voters, you're all probably familiar with these cases. They filed multiple lawsuits in the Supreme Court of Ohio against the Ohio Redistricting Commission. League of Women Voters filed these lawsuits asserting that new districts for the Ohio State House and State Senate were partisan gerrymanders that violated the Ohio Constitution. The lawsuits invoked the original jurisdiction of the Ohio Supreme Court. So there are 3 of them. There's League 1, League 2, League 3. In League 2, the League of Women Voters asked the court to move the date of the primary last year. And the court decided that it lacked the authority to move the primary. And they said, well, since the General Assembly failed to approve districts that were constitutional, they can take up this issue and move the primary if they want to. But then after that decision, the League of Women Voters filed another motion, this time in one of their other lawsuits. It was actually in League 1. They again invoked the court's original jurisdiction and requested that the date of the primary be moved. And not surprising, the court denied the motion again, but then there is a very strong dissent from Justice Fisher in this case. So Justice Fisher writes this: I'm saddened, disappointed, and concerned that respondents' motion and supporting memorandum fail to mention the case law directly contrary to their position. Respondents request that this court move the date of the primary election, but the respondents fail to mention that in League 2, a case in which they were parties, the majority opinion clearly sets forth the fact that this court lacks the authority to alter the date of the election. As parties in League 2 and League 3, the respondents were aware of the majority opinion's resolution of the primary election date issue, and the extensive coverage in the mainstream media further demonstrate that the failure to disclose the controlling authority was possibly done knowingly. So he's saying, if it isn't bad enough that you were parties to this case, you knew about our prior ruling, but it's also been all over the media. There's just no way that this could have been a mistake, Justice Fischer saying. So he goes on to say, closes by saying, the situation is extremely disappointing. I can only hope that respondents' failure to cite to League 2 was an oversight, but he basically said that he knows it isn't. It's a sad day in the legal profession and this state's judicial system when lawyers do not include a simple but see citation to contrary authority in any filing in this court or in any other court. I just think, ouch, when I read this, ouch, being called out by the Supreme Court of Ohio, it hurts. Next case I'm going to talk about. Next case is a Seventh Circuit case, School versus One West Bank. This is a 2013 case. And here we have mortgage holders who sued their bank after the bank failed to modify their loan and initiated a foreclosure. The bank filed a motion to dismiss, but failed to address recent and controlling Seventh Circuit authority. These were Skadden Arps lawyers from DC and Chicago. They were called out by name in an order by the judge denying the motion to dismiss, and they were ordered to show cause in writing why they shouldn't be sanctioned for violating 3.3 and Federal Rule of Civil Procedure 11. Ultimately, sanctions weren't imposed by the court for two reasons. One is because the lawyers showed appropriate remorse. They should have included this authority in their brief. It was an obvious oversight. They were sorry about that. And the judge also recognized that by calling them out by name, putting their names in the order, that was embarrassing. They probably suffered enough just by being called out, and that was probably already a really severe sanction. It's another case where lawyers failed to disclose, this time, withdrawn authority. So this is interesting. The Department of Interior was taken to task for failing to inform a federal court that it had withdrawn its own authority. So the Department of Interior was sued by the Mashpee Wampanoag tribe for rejecting their plan to put a casino on reservation land. And in its defense, the Department of the Interior relied on its own M opinion that contained a two-part test that they were relying on to determine whether a tribe was under federal jurisdiction when the Indian Reorganization Act was passed, and there's a provision allowing land to be taken into trust for tribes. So an oral argument is scheduled on the issue of whether the agency's application of its own M opinion was arbitrary, capricious, and abuse of discretion, or contrary to law. But instead of appearing to defend their opinion, they decided the Department of Interior would withdraw it, and they replaced it with a new four-part test and didn't bring this change to the court's opinion. So the federal district judge says about that, the court frankly is shocked that the government did not bring this change to the court's attention and discuss its relevance or lack thereof to the pending motions for summary judgment and preliminary injunction. The court was left to discover this change on its own less than a week before oral argument on the application of the M opinion. So this is a Massachusetts case, but if I bring us back to Ohio and our Ohio aspirational ideals for all lawyers, we are called to assist the judiciary in determining the applicable law. And we also have to give recognition to the judiciary's obligations of informed and impartial decision-making. Pulling the rug out from under the court like this before an oral argument is unprofessional and could amount to a violation of the rules of professional conduct. So those are some civil cases for you. So I have three examples of for criminal law people, my criminal law people. So two for prosecutors, and there's one case involving a public defender. So the first one is disciplinary counsel versus Spinazzi. And the respondent here was a part-time assistant prosecutor in Sylvania, Ohio. An individual in Sylvania got pulled over for OVI in late 2017. In early 2018, Spinazzi gets hired and he gets assigned to handle this OVI case. And so one of the first things that he does is he schedules a meeting with defense counsel and the officer that handled the OVI arrest. And they reviewed together the footage from the body cam footage. So they watched the video together, and at the end, defense counsel says, my guy will take a physical control, which in my experience is what they always say, right? We'll take a physical control. And the officer said, no, I don't think any reduction is appropriate here. I don't agree to it. The officer, I'm sure, also knew that this defendant had 2 prior alcohol-related convictions. So it probably wasn't appropriate to offer a plea like that. But Spinazzi decided that he was going to offer the reduction anyway. So they go into court and they're putting the plea on the record. And the judge is pushing back. Why would you offer this defendant a physical control? He has 2 prior alcohol-related convictions. You know, what's going on here? And so the lawyer says, well, you know, I'm not sure that we can put him behind the wheel of the car. There's a question about whether the officers actually observed him driving. So, you know, we have some evidentiary issues. So the reduction is appropriate. And I'm wondering, what is defense counsel thinking at this point? Because he knows that the prosecutor is lying. They watched the video together, but, you know, certainly his client wants this deal. So defense counsel stays silent. And I also wonder what the judge is thinking at this point, because why would you offer anything if you can't put the guy behind the wheel of the car? You didn't observe him driving. Why aren't you dismissing this? But the judge can only deal with the information that is in front of him. The judge accepts the plea. But this plea gets back to the prosecutor's supervisor, and she goes and reviews the internal case notes that the lawyer put in after the plea. And the case notes show that the reason for the reduction was that the reason that the case was reduced was because the judge was going to dismiss the case. It's what he put into the record. So the supervisor took the additional step of going and reviewing the audio from that plea and realized that the prosecutor was lying. And so he got fired, and the respondent in this case got a 6-month suspension for submitting false statements to the court, for conduct involving dishonesty, fraud, deceit, or misrepresentation, and for conduct prejudicial to the administration of justice. So this is where you see these two together: conduct prejudicial and false statements to a court. Next case is disciplinary counsel versus Philibom. So this is a Butler County prosecutor, assistant prosecutor. And in 2010, an assistant prosecutor in his office presented a case to the grand jury. The charges were aggravated robbery and felonious assault, but the prosecutor didn't submit any evidence related to any gun specification. So we just have these 2 charges. So the prosecutor, Philibom, takes the indictment to his legal assistant. He sees that there was nothing submitted on the gun specification. He tells his legal assistant, I want you to add this to the indictment. And you'll see that Philibom has 2 opportunities. He's sort of going down this road where he's planning to lie. And his first opportunity to sort of take the off-ramp is when this legal assistant says to him, I don't feel comfortable with this. I'm not going to add this to the indictment. But he tells her, no, I want it in there. And so she follows orders. She adds the gun specification to the indictment. So then he takes the indictment, he presents it to the assistant prosecutor that presented the case to the grand jury. This guy knows there was no gun specification presented to the grand jury. But Philibom says, I want you to sign this. The guy says, no, I'm not going to do it. So this is his second opportunity, or maybe he should be thinking, maybe I shouldn't do this, but he doesn't take that off ramp either. He signs it himself and causes it to be filed with the clerk's office. So not only does he get disciplined for this conduct, but he's also criminally prosecuted. He pleaded guilty to dereliction of duty and got a 90-day suspended sentence. The Supreme Court of Ohio, in issuing his discipline, gave him a 1-year suspension with no stay, so it's hard time out of the practice of law, for false statements to a tribunal, conduct involving dishonesty, fraud, deceit, or misrepresentation, and again, conduct prejudicial to the administration of justice. So those are my two prosecutor cases. Now, my third one for criminal law practitioners is Dayton Bar Association versus Swift. And here we have, with the way that this case came to the attention of the Dayton Bar Association, was the Dayton Daily News said that the respondent in, I think it was 2008, he was the highest paid lawyer for court-appointed work in Ohio. I guess this caught their attention. So Swift was a court-appointed lawyer for Montgomery County in the juvenile court division, but he also worked in 3 other counties doing appointed work. He gets paid $50 an hour for in-court work, and he gets $40 an hour for out-of-court work. And an audit revealed that he routinely billed for 14-hour days and some days for 30-hour days. In 2008, over these 4 counties, he averaged 8-hour days for 365 days. He made over $131,000 doing court-appointed work in 2008. He failed to keep independent time records for all of this work that he's allegedly doing. He also billed in half-hour time increments, which just blows my mind. He failed to keep time records for the other lawyers that he was supervising. And the court said that his failure to keep any records prevented them from knowing the full scope of really, I think, the crimes here. There was so much money that was really stolen from the government, but the court accepted his stipulation that he would pay back $50,000. So this lawyer, Swift, got a 2-year suspension with a 2nd year stayed. So he gets 1 year out of the practice of law, and then the 2nd year is stayed. He violated 3.3A for making false statements to a tribunal. And so maybe what's important to point out is that these false statements were not in connection with any case in particular. He just submitted his bills to the court. This was considered a false statement to the court. And then he also is found to have violated 4.1A for false statements to third persons, because he also submitted these bills to the Office of the Public Defender, and that amounted to misconduct. Then he was also tagged with 8.4C for conduct involving dishonesty, fraud, deceit, or misrepresentation. Again, conduct prejudicial to the administration of justice, and also conduct adversely reflecting on his fitness to practice. Now we're going to talk about unprofessional conduct toward courts. And you'll notice here that these aren't incidents that occur in open court. These are, again, things that are written, that are filed with the court, but still considered unprofessional conduct toward courts. So the first one is Columbus Bar Association versus Bayhan. And in this case, the respondent and her husband attended a holiday party that was hosted by the Logan County Bar Association. So at this holiday party, a local judge is supposed to get a mock award. And when the respondent and her husband arrive, she begins drinking wine. It says that she had 3 glasses of wine because 3 glasses is her public limit. You don't know what the private limit is. But apparently 3 glasses was still too much alcohol for her. So this mock award ceremony begins. The lawyers around her tell her she needs to calm down. She's getting a little bit loud. One person said that she appeared to be unsteady on her feet, but somebody else testified that no, she wasn't, because she stood straight up And during this award ceremony, she called the judge. You can see exactly what she called him, all of those names. And so, of course, a disciplinary complaint gets filed against her by the Columbus Bar Association. So it's not an excuse, but maybe it's interesting to know that the reason that she didn't like this judge was because he had filed a grievance against her, and she was scheduled to appear before the Board of Professional Conduct 2 days after this party on this grievance. So she was upset. I'm sure she shouldn't have been at that party anyway. So she gets charged under GovBar Rule 4. So what in the world is GovBar Rule 4? Under Rule 4, lawyers must maintain a respectful attitude towards courts. So we're not thinking about our duties under the rules for the government of the bar. So GovBar Rule 1, for instance, talks about the bar admissions process. Judge Groves mentioned the bar admissions process. Once you get through character and fitness, you're not thinking about GovBar Rule 1 anymore. And GovBar Rule 7 talks about the unauthorized practice of law. And if you're admitted under Rule 1, you don't need to worry about Rule 7. So what is this Rule 4? So this is part of Ms. Behan's argument when she's defending herself in front of the Board of Professional Conduct. She doesn't believe that GovBar Rule 4 should be a standalone violation that she should have to deal with. She also argued that her conduct didn't support a finding because it amounted to political speech. It was protected by the First Amendment, that it wasn't directed toward a court. She's just at a holiday party, right? And she argued that she simply disapproved of the judge's conduct that led to the bar presenting him this award. Bar Association argued, of course, that this wasn't political speech. This was an alcohol-induced rant. It's not protected. And the Supreme Court of Ohio agreed and noted that by accepting the privilege of practicing law, attorneys accept certain conditions and duties as officers of the court, and that while the First Amendment may be a defense in some situations, this was not it. So Ms. Behan got a 6-month suspension. She was also found to have engaged in other misconduct. I left that out because it's really the holiday party, and it's the GovBar Rule 4 thing that I want you to concentrate on. Next case is disciplinary counsel versus Frost. In this case, the respondent filed an affidavit of disqualification against a Cuyahoga County judge. Excuse me. But this affidavit didn't have a whole lot to do with the judge or even with her client's case. Respondent filed in this affidavit false accusations of bias and corruption against several judges and the Cuyahoga County prosecutor. She also accused a federal judge of receiving his nomination to the bench through, quote, improper financial contributions to prominent politicians, and falsely claiming the judge was under investigation by the FBI for his racist conduct. She filed a baseless defamation action against opposing counsel. And interesting to know, this federal judge that she complained about actually appeared and testified in this disciplinary hearing. And of course, disputed that there was any prejudice or impropriety. It would be humiliating to have a federal judge come into your disciplinary hearing and testify against you. Respondent received an indefinite suspension, and she's required to provide medical proof that she's mentally fit to return to the competent, professional, and ethical practice of law before she's reinstated. Oh, and I forgot to mention that again, Frost gets disciplined also under GovBar Rule 4. So the court is taking this seriously, our duty to act with dignity toward the courts. Next case is Cleveland Metropolitan Bar Association versus Morton. In preparing for my program, I talked with my friend and your friend, Susan Audie, who said that you could probably spend about an hour talking about the Morton case. And she's right. I'm only going to talk about it a little bit, but it is an important one. So the respondent here represented a client who wanted to reduce the tax valuation of a house in Cuyahoga County. He appealed a decision of the Board of Tax Appeals to the 8th District Court of Appeals, alleging that the BTA improperly assigned the burden of proof for the property owner. In a ruling that upheld the decision of the BTA, the Court of Appeals cited a Supreme Court case. It was called Moskowitz versus Cuyahoga County Board of Revision, and it rejected that burden shifting argument that the respondent made, saying that the county's fiscal officer was presumed to have carried out their duties in good faith, and absent a showing to the contrary. And the court noted that the property owner didn't challenge the BTA's finding in the appeal. But the respondent pursued an appeal to the Supreme Court of Ohio, and in his memorandum in support of jurisdiction, claimed these things. First, that the appellate panel could only reach its conclusion because they're politicians committed to maximizing revenue for their political cronies. He also extensively criticized the Supreme Court justices for the political nature of the Moskowitz decision. He said the most obvious evidence of the political nature of the Moskowitz decision was the decision to delay the decision until Justices Pfeiffer and Lanzinger retired from the court and were replaced by Justices Fisher and DeWine. Chief Justice O'Connor, he said, was to blame for the delay because it all happened under her watch. So a formal complaint was filed with the CMBA, and then following a hearing before the Board of Professional Conduct, the respondent was found to have violated 3.5A for engaging in undignified or discourteous conduct that's degrading to a tribunal. Also 8.2A for making a statement the lawyer knows is false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judicial officer. And 8.4D for engaging in conduct prejudicial to the administration of justice. So Morton objected on 3 grounds. He said first that there was no standing to bring a case against him because there was no grievance that was filed with the Bar Association. And the court overruled that pretty quickly and easily because Bar Associations, grievance committees often will initiate investigations on their own initiative. They don't need a grievance to be filed in order to open an investigation. And then his other 2 objections are sort of combined. He argued that his speech was constitutionally protected and that the court shouldn't have relied on its decision in Disciplinary Counsel versus Gardner, which you may be familiar with, but if you're not, I'll back it up a little bit. In 2003, Gardner was disciplined after he filed a motion for consideration of an appellate court decision, also happened to be an 8th District decision. And in that motion, he improperly accused the appellate panel of harboring bias toward the prosecution, corrupting the law, and issuing a result-driven opinion in rendering its decision. And so Mr. Gardner got a 6-month suspension, not a state suspension, but got 6 months out of the practice of law for filing that brief. So in that decision, the Supreme Court of Ohio adopted an objective standard to determine whether a lawyer's statement about a judicial officer is made with knowledge or with reckless disregard as to its truth or falsity. So Morton argued that the test in Gardner impermissibly punishes false speech that is negligently made. The Supreme Court explained in Gardner, and then they reiterated in the Morton decision, that disciplinary actions against lawyers aren't intended to be used to shield judges from unpleasant criticism. That is not what's happening here. The point is to preserve public confidence in the fairness and impartiality of our justice system. So unlike in a defamation action that seeks to remedy a private wrong, which you see on the screen, the point here is to preserve public confidence in the justice system. So the court overruled Morton's objections. He got a 1-year suspension with 6 months stayed. Justice Kennedy, however, said in a dissent that she would overrule the Gardner decision, that she would dismiss the complaint against Morton. And Justice DeWine also wrote a dissent. He said that he's not so thin-skinned to believe a sanction is warranted against Morton, and that neither the First Amendment nor our disciplinary rules allow us to punish an attorney just because something he says gets under our skin. So I have a little bit of the oral argument. I don't know if I'm going to be able to show you any of it. Let's see how good I am. There is a brief exchange near the end where Justice
Case this morning is 2020-1521.
Patient, but the justices.
I can't read the numbers.
All right, stop right there. Stop right there. How do you know that?
Because
There we go.
As an attorney, you remember what that is?
I may have forgotten it, but I mean.
Well, part of it is to show respect to judges, right?
Judge, justice, Youngly, you took an oath, you were as a justice to follow the law. Right? The law is not fair, we can live at the expense of the taxpayer. We have a constitutional provision of free speech in the state of Ohio. By encouraging responsibility, you're not going to be that way. You also took an oath to and I would urge you to follow the law.
Yeah, attorneys very often tell me that they don't think in my decision making that I did follow the law. They disagree, and an attorney, as your opponent pointed out, has an obligation to point out when that takes place, and I have no problem with that. But you know, I show respect to attorneys, and I expect attorneys to show respect to the court and the process, and there's reasons for that. It's not just because we think it's a good thing to do, because as a profession, we want the public to have confidence that the court is independent and it's free of.
All right, I'm going to shoot just the last couple of minutes. Oh, I won't bother because my fingers. But in the last couple of minutes, the justices were sort of entertained by how the oral argument was going. And at the end, Mr. Morton says to Chief Justice O'Connor, if what I did was so bad, then why didn't you file the grievance? And she says, oh my God. And she ends them. And that's pretty much how it ends. But Mr. Morton's hearing, his disciplinary hearing also took place by Zoom. Very difficult. Difficult to be involved in these cases anyway, but really difficult to do them virtually. So if you have time, you can watch that one on your own. Let's see if I can get back here.
Our final case is the Metro Bar.
Whoops.
Go back to the PowerPoint now?
Yes, thank you. Thank you so much. Okay, so now we're going to talk about unprofessional conduct toward opposing counsel. I have another video for you. So this case is DigiArt versus Danny Casale. I'll tell you a little bit about the underlying case just because. But Casale, if you don't know him, he's a New York City-based artist. He became famous when this video went viral about 10 years ago. He's known for these surreal sort of cartoons, crude animations. They're popular with like our kids. We're probably not into it, but it's sort of funny. So I'll just show you a little bit of Mr. Casale's art.
I was scrolling down my Facebook timeline.
Yeah.
And it said snakes have legs.
No.
Yeah.
I gotta go tell everybody.
Yeah, you go tell everybody, man, because it's true. Whoa, are you a snake?
Yeah, man, I'm a snake.
I heard that you have legs, man.
That's some dumb shit.
Reputable news source. Yes, it's called the Daily Testicle.
We believe something from the Daily Testicle. We think this is true because we read on the internet, right? Yeah. You should stop that.
forever. Stop being, no, just stop being dumb. The internet is an amazing tool that can be used for amazing things, but you should stop being an idiot. Hi, friend. Sadly.
Okay, so you see why our kids like this stuff. And there you get a little bit of, you can see what my son likes to watch. Maybe you can help me advance to the next. Oh,
I was scrolling.
oops, sorry. Oh, well, let me tell you how Casali, or why Casali is important. So this lawyer gets an invitation from this company. They send him a contract to sign. They're inviting him to partner to create a new entity that would become DigiArt. I won't go back to my slide because the video will play all over again. But he gets this contract and it has a bunch of blanks in it. The dates aren't filled in. The effective date of the contract is not filled in. And he's an artist. He's not a lawyer. So he just signs the thing and he sends it back. And so it never becomes a thing. But he eventually creates his own, it's called Cool Man's Universe, NFT, so non-fungible token project. And that was what they were supposed to do under this contract. He goes and does it on his own. Then DigiArt decides that they're going to sue him. So Casali hires a California-based lawyer to represent him. He gets sued in the state of Florida, and Casali is deposed in Florida. So the California lawyer is admitted pro hoc vice in Florida. And so they go through the deposition. Casali files a motion for summary judgment. That motion is ultimately granted. But in reviewing the motion and reviewing the evidence, the court read the transcript from the deposition, and they decided to footnote in its order granting the motion for summary judgment. They called out Casali's lawyer for his behavior during the deposition. And so this is what the court says. In reviewing the evidence, in this case, the court became concerned with the conduct of defendant's counsel. I won't name him. During the depositions in this proceeding, he made numerous aggressive, rude, disparaging, and unnecessary comments to both deponents and opposing counsel. The lawyers reminded that when appearing before this court, he's bound by the Florida rules of ethics. As relevant, the rules regulating the Florida bar specifically prohibit attorneys from engaging in conduct in connection with the practice of law that is prejudicial to the administration of justice, including to knowingly or through callous indifference, disparage, humiliate, or discriminate against litigants, jurors, witnesses. It goes on. This court will not tolerate the lack of civility evidence in the deposition transcripts. The lawyers hereby placed on notice that this court can and will report any further such conduct in this case or any other before this court to the proper licensing authorities, which I'm reading this makes me think they may not know where to report it. I mean, he is a California lawyer. He's engaging in this misconduct in Florida. There are rules that address this situation. But so remember, if you are admitted pro hoc vice or you are practicing on a limited basis under professional conduct rule 5.5, you are subject to the rules of professional conduct in that jurisdiction where you are engaged in the practice of law. So this next case, Florida Bar versus Adams, I don't have time to go into. It is the craziest case that you have ever heard of. I will give you like 30 seconds. 3 lawyers representing a well-known DJ in Florida. These lawyers decide that they're going to set up opposing counsel the night before they're supposed to be in court. They get their legal assistant to buy drinks for opposing counsel in this restaurant. She gets him very drunk. Even though he drove to the restaurant, she convinces him to drive his car. They have the police waiting. He gets arrested. It's absolutely crazy. All 3 lawyers got disbarred is the end of the story. So much, I can't even get into it, but it is the worst case. I think we can, I'm sure, think of lawyers in our own community that might be guilty of trying something like this or might be willing to try something like this, but these Florida lawyers actually got caught. It's terrible. Okay, so in my last few minutes, how much time do I have? All right. So I want to talk about the oath that we all took as lawyers when we became, when we were admitted to the practice of law. You heard Justice Donnelly ask Mr. Morton during the oral argument in Morton's case if he remembered the oath that he took. And Morton said, you know, I don't really remember it. That's probably true for all of us. Do we really remember the oath that we took? I know that I don't. So let me remind you. So you all said these words. I, Heather Zerke, hereby swear that I will support the Constitution and the laws of the United States and the Constitution and the laws of Ohio, and I will abide by the Ohio rules of professional conduct. In my capacity as an attorney and officer of the court, I will conduct myself with dignity and civility and show respect toward judges, court staff, clients, fellow professionals, and all other persons. I will honestly, faithfully, and competently discharge the duties of an attorney at law, so help me God. You all said these words. And in 1997, the Ohio Commission on Professionalism adopted a lawyer's creed. If you don't have a copy of the lawyer's creed, you can get one from the Supreme Court's website on the page for the Commission on Professionalism. So these are not more rules that we're required to follow, not a basis for discipline. These are just the things that as lawyers we should all be aspiring to all the time. So let me just read this for you, and I encourage you to get a copy of it for yourself. And I'll highlight my favorite parts. So to my clients, I offer loyalty, confidentiality, competence, diligence, and my best judgment. I shall represent you as I should want to be represented and be worthy of your trust. I shall counsel you with respect to alternative methods to resolve disputes. I shall endeavor to achieve your lawful objectives as expeditiously and economically as possible. To opposing parties and their counsel, I offer fairness, integrity, and civility. I shall not knowingly make misleading or untrue statements of fact or law. I shall endeavor to consult with and cooperate with you in scheduling meetings, depositions, and hearings. I shall avoid excessive and abusive discovery. I shall attempt to resolve differences, and if we fail, I shall strive to make our dispute a dignified one. I love that line. How many of us are striving to make our disputes dignified? If we can't agree, there will be many times when we can't agree, but are we trying to argue with dignity? Are we striving to make our disputes dignified? To the courts and other tribunals and to those who assist them, I offer respect, candor, and courtesy. Where consistent with my client's interests, I shall communicate with opposing counsel in an effort to avoid or resolve litigation. I shall attempt to agree with other counsel on a voluntary exchange of information and on a plan for discovery. I shall do honor to the search for justice. Are we attempting to disagree as we're representing our clients? To my colleagues in the practice of law, I offer concern for your reputation and well-being. I shall extend to you the same courtesy, respect, candor, and dignity that I expect to be extended to me. Are we offering concern for our opposing counsel and for their well-being? To the profession, I offer assistance in keeping it a calling in the spirit of public service and in promoting its understanding and an appreciation for it by the public. I recognize that my actions and demeanor reflect upon our system of justice and our profession, and I shall conduct myself accordingly. And then last, to the public and our system of justice, I offer service. I shall devote some of my time and skills to community, governmental, and other activities that promote the common good. I shall strive to improve the law and our legal system and to make the law and our legal system available to all. If you haven't read this lately, if you've never read it, I recommend that you keep it somewhere close by, that you're remembering to try to keep your disputes dignified, that you're attempting to agree with opposing counsel where you can, that we're showing appropriate concern for the reputation and well-being of our opposing counsel, and that in all that we're doing, we're promoting the public good. And that is all I have for you, unless you have any questions.